Luka Kimaro, he said that the grounds that are presented must be grounds that a reasonable person applying their mind to the fact might actually find it to be a justified ground to put forth. And yes, he's an MP, for sure, and a person of influence. He has to be for him to have been elected as an MP. And his advocates argued that the fact that he is an MP should not be used against him. The leadership position should not be advanced against him. And I agree, that should not be advanced against him. But it is also a fact that he is a person of influence. As a political leader, he is a person of influence. And a reasonable man would not doubt for sure that he is a person of influence. The court was told that witnesses are yet to be interviewed, and there is a fear that upon release of the respondent, a sitting MP, where witnesses are required and witnesses will be sought from within his jurisdiction mostly, and perhaps, I don't know, if the clips will show other witnesses, I don't know. It goes without saying that that is a reasonable ground, not to use the leadership position against him, but to consider that a man serving as an MP has such influence that in the current state of these investigations, if he was to be out on bail, it is quite likely that witnesses might not come forth, and especially given that the allegations that are being made against him are incitement to violence. Those are the allegations. It might be very difficult for witnesses to come forth when the respondent is out on bail. And I do find that whereas it has not been shown, and I agree with the respondent's counsel on this, it has not been shown that so far he has interfered with anyone. In fact, we do not know who will be called as witnesses. I do find that to be true. We don't know who will be the witnesses. It has not been shown that he has interfered so far because the witnesses are unknown. But I do find that it is reasonable, it is a reasonable fear that the DCI has presented before this court, that witnesses may not freely cooperate while the respondent is out on bail. I find that to be a reasonable ground for this court to consider in considering whether to allow the application for his continued detention or not. And as pointed out by counsels for the respondent and considered by counsels for the applicant, witnesses can be placed under protective custody. That is possible, and if there is fear that because of his status witnesses might not feel safe, then there are protective measures that can be undertaken. I do agree with both counsels on that issue. I do also agree with the applicant's counsel's submission that witness protection that can be undertaken is a process, and before it can be undertaken or be sought if necessary, it is important to safeguard the atmosphere such that witnesses, as may be available to the alleged utterances, can be identified and necessary protective steps taken. Okay. So I find that it is important, even though there are protective measures that are allowed, it will be important, first of all, to secure that environment so that the witnesses can come forth if any person witnessed the said utterances, and then now the DCI can apply to have such persons as may be found to be protected and put under protective custody. So I do find that this is a just reason. This is a just reason, and it is just because the investigations must be facilitated. The investigations must be facilitated. Then issues of guilt and can later be determined should the respondent be charged. So I find this is a just reason for the purpose of facilitating investigation, that it is warranted for this court to limit the respondent's liberty. rather I am agreeing that continued detention is necessary in the interest of the security and of the larger public, including the persons who might have witnessed the event and will be willing to be witnesses, the alleged event, and will be willing to be witnesses to the matter. For continued detention, on that ground, I find that it is justified. We do not need to have a host of grounds, as long as there is one and convincing ground that warrants detention, then it is right to exercise that discretion. However, I find that the 14 days detention sought by the applicant is unduly long. How long would it take to identify if someone did witness and is willing to be a witness? How long would it take for the DCI with all its muscle and to identify them and take up the necessary protective measures if necessary? So 14 days is unduly long in the circumstances, because it has not been shown that so far he has reached out or interfered with anyone in particular. There is only a fear that the persons who might be witnesses in the incitement to violence charge, if brought forth, might not come out when he is out on bail. So I find the 14 days is unduly long, and the DCI can and must expedite the processes it needs to undertake in identifying witnesses and taking the respective protective measures, if any, are required. So I do allow the application, but I direct that the respondent shall be held for 3 working days. He will be held for 3 working days, and he will be held at Kileleshwa. 3 working days, today, Monday, and Tuesday. He will be held for 3 days only at Kileleshwa Police Station. The DCI has to move up and do all it can to secure witnesses if they have to make further applications. But for now, the application is allowed with the rider that it will be for only 3 working days, and he will be held at Kileleshwa Police Station. We will give a date when we will issue further orders. That's the court's decision.
Tusaidie na hiyo kama ni draft.